Okay. My name is Ken Foreman. I'm the current chair of the Zoning Board of Appeals, and I will call the May 3rd meeting of the Zoning Board to order. Let me ask everyone, please, to silence your cell phones, if you have not already done so. And even though I say that every meeting, someone's phone rings usually in the middle of the meeting, so please do. I'll start also by introducing the board. So to my left is T.J. Hurry, who's vice chair of the board, and Ed Van Kuren, who's a voting member of the board, and I guess is going to serve as our clerk tonight. Is that correct? And Paul Murphy, voting member of the board, Robert Dugan, who's an associate member of the board, but he will be on all hearings tonight because there are just 5 of us. So, as I'm sure many of you know, we're charged, the Zoning Board of Appeals is charged with applying our zoning bylaws and considering requests for special permits, for variances, for appeals, as provided by those bylaws that have been voted by town meeting and approved by the Attorney General's office. And so our goal, of course, is to hear full and fair testimony from and have discussion on each project prior to rendering a decision. So the process works like this. We will begin each hearing by asking the clerk to read a public announcement of that hearing and then to present any pertinent information from the files, such as referrals from town departments. And then the applicant's representative will be given 15 minutes to present the project. The board will then question the applicant, and then we will invite the public to comment. And if you wish to comment, we ask that you raise your hand, wait to be recognized by the chair, and then go to the podium and state your name clearly for the record so that our recording secretary, who is tonight is Ashley DeMello, can get that information. Please direct all your comments to the project and through the board, rather than to whoever is out there in the public that you want to talk to. We're the ones making the decision. Obviously, we ask that you avoid making any derogatory remarks about anybody. If you want to talk, we do limit comments to 2 minutes. Okay. So then the board, we hope we'll get answers to all your questions, and if the board feels they have enough information, we'll close the hearing. May have some further discussion, and then take a vote. If we feel we need additional information, we will continue the hearing to a date certain in the future. Votes for special permits require a supermajority, so that's a 4-to-1 vote. With that, I think we can start with, let's see, tonight we have 3 continuations and 1 new hearing. The first continuation, which is 082-17, Lawrence Lynch, 0 Blacksmith Road. Is there anything new, Ed?
This has not been, it's been opened, but there's been no testimony to date.
So being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 40A, Massachusetts General Laws, are hereby notified that Lawrence Lynch Realty Corporation of Falmouth, Mass. filed an appeal with the Falmouth Town Clerk pursuant to Mass General Laws 40A and 15 and 240-202 of the Code of Falmouth, appealing the building commissioner's determination that the subject property may not be used for a site for the solar photovoltaic array as a matter of right on subject property known as Blacksmith Shop Road, 0 Blacksmith Shop Road, Hatchville. And there's a comment from the Planning Department applicant before the Planning Board on 9/26 for proposed town meeting article to change the zoning from AGA to LIC, and that was the only comment.
Okay, and I guess that was defeated.
What was defeated is allowing the solar arrays to be in agricultural.
All right, is that it? So then, for the applicant, we have Ed Kirk.
Thank you, Mr. Chairman, members of the board. My name is Edward Kirk. I'm an attorney with an office in Osterville, and I'm here representing the Lawrence Lynch Corporation. This appeal was filed back in September, and there's been some other activity taking place with respect to the use of this property. And if you don't mind, maybe I'll just give you a little bit of that background. It was referred to just now, town meeting action and so forth. The subject property is 65 acres located on Blacksmith Shop Road. For many years it was the location of what they call a pit. A lot of excavation was done there, hauling sand and gravel and so forth. And it's quite scoured out now. There's quite a drop from the street grade down below. Apparently it has, location is such with the exposure to the sun and so forth that a company called Borrego Solar Systems, that's a national company that installs these solar farms, approached Lawrence Lynch and were very interested in using this site as the location of a solar farm, solar voltaic array as it's called in the bylaw, at that site. And they did enter into a lease agreement to do that. The next step was to see about permitting and zoning and so forth. The bylaw, the Falmouth zoning bylaw, allows these ground-mounted solar arrays in light industrial C districts only. The phrase is defined in the definitions in the bylaw. This clearly would be, what's proposed here would meet that definition. But the bylaw says it can only take place in light industrial C. And that begins the rub here. Because the general laws, Chapter 40A, Section 3, addresses, among a number of other uses which bylaws may not prohibit, such as educational uses, religious uses, agriculture. There's a list that the legislature has said towns may not prohibit these kinds of activity by means of prohibitions in the bylaw. Falmouth bylaw is written in such a way that if it's not allowed, it is prohibited. 240, Section 217 and 218, and I think that's the way it's always been construed. If you don't see it, that it's permitted and expressly allowed, it's prohibited. So what you have is a situation where these uses, or this particular use that's allowed in the light industrial district, is in fact prohibited everywhere else in the town. And what the statute says is that no zoning ordinance or bylaw shall prohibit or unreasonably regulate the installation of solar energy systems, which is one category of a solar collection, and or the building of structures that facilitate the collection of solar energy, except where necessary to protect the public health, safety, or welfare. So what you have here is seems to be a conflict between what the general law says the town can do in terms of dealing with these solar arrays and what the legislature has said you can't do. So we went to the building commissioner, presented a formal letter. We didn't go through the process of presenting a whole series of plans and site plans, but we did present him with our presentation, our argument, and he responded and said that he disagreed with us, and he said, basically took the position that since a solar array is allowed in a light industrial district, it is therefore not prohibited. And we disagree with that interpretation of the statute. Where the bylaw says you can't prohibit, it means you can't prohibit anywhere. You can't pick and choose where the prohibition takes place. So we then filed our appeal here, and then following some discussions with town personnel, we were encouraged to seek legislation at town meeting that would alter the status quo. And the suggestion was to present an article at town meeting whereby this site would be, the zoning would be changed from agricultural, which it is today, to light industrial C. And then it would fall under the provision of the bylaw where it's expressly allowed. So this appeal was put on hold. And so we did draft an article, had hearings before the planning board. Neighbors came, they expressed their concern that they're all for solar, but the problem would be, what if this particular enterprise did not continue on, or if it ceased, or if they chose to pull out? Then you'd have a piece of property that was zoned for light industrial, and they'd be concerned that industrial uses would come in there. That's fair concerns. But in any event, the planning board gave us a positive recommendation to go to town meeting floor. But at town meeting, I think the town meeting members were mindful of the concerns of the neighbors, and they didn't want to just give a blanket change of zoning to this particular parcel where those doors, other doors might be open. And I might add that the town of Falmouth itself, I think at their landfill, they went through the same process. They operate a solar array at the landfill, and they did that because they got a zoning change through town meeting. So we then, we were informed that the planning board was going to take this issue up again, and they drafted their own article whereby certain agricultural districts, including ours, would be, that this use, solar array, would be allowed in agricultural districts. And they held the hearing, the statutory hearing, as they're required to do. There were no objections. But then the planning board, for whatever reason, decided to recommend indefinite postponement of their own article. So it never went forward on town meeting. And so here we are back with the zoning question for the board to decide. It's our position that the statute is pretty clear. You can't prohibit this use anywhere in the town. You can't partially prohibit. You can't pick and choose where you're going to prohibit. And the statute also says that they can't unreasonably regulate. That's an interesting phrase. I suppose what the flip side of it is, it means you can reasonably regulate, but you can't unreasonably regulate. But that term to me suggests that you're regulating a use which is already permitted. It's already allowed, and you can perhaps impose some regulations if need be to have some degree of control. Within the context of 40A Section 3, when they talk about educational uses, they describe reasonable regulations relating to bulk, height, yard size, lot area, and so forth. So, you know, to the extent that there are regulations already in place in this particular district, those could be reasonably applied. But the use itself for the solar array cannot be prohibited. And the bottom line here is, and I don't want anyone to be offended or get into fights, but the statute trumps the bylaw. And since the statute says you cannot prohibit this use, it's our opinion the building commissioner was, his opinion is not the correct opinion, and that you should so state in a decision.
Okay. All right, let's see if the board has questions about your interpretation.
No questions.
Yeah, I just have a quick question. Attorney Kirk, are you aware that there are a lot of towns in the Commonwealth of Massachusetts that allow large-scale ground-mounted solar farms, not wholesale throughout the whole community, but they do regulate it just to certain districts, and that's very prevalent throughout the Commonwealth? Are you aware of that?
I'm just dealing with this
Okay.
particular bylaw and haven't looked at any other bylaws to see how that's treated.
Sure. That's all I have. Thanks.
Excuse me, are those arrays going to be down in the, what you call as the pit, so you won't be visible from the
Yes.
highway?
Yeah, the thing is, with this particular location, you know, obviously there's no noise and there's no dust, and if you're riding by, they're not visible. I think it's a 30-foot drop or more from grade down to where these structures would be located.
That's all I have.
TJ?
Attorney Kirk, what I'm struggling to understand is how is this different from any other zoning restriction that we have, especially zoning restrictions that require special permits through this board? Just by way of example, the famous law school example is adult uses. And I'm not going to go into every adult use, but it's defined in our zoning bylaws. And that allows special permits in light industrial A and business 2.
Well, the difference in this particular case is that the language of the statute, what the legislature has said, that this use cannot be prohibited. That's the heart of the whole argument here, is what has the legislature said about this particular use. In 48.3, they've selected any number of things that, for matters of policy, where can you put a school? You can't discriminate and say you can't have an educational facility in this district. You can't prohibit where a church goes. You can't prohibit the use. And this is just one of those uses for whatever reason, probably with the emphasis on the environment and renewable energy and sustainable energy. But the legislature, we always add in its wisdom, has decided that this kind of a solar operation is entitled to that same kind of protection.
And a follow-up question, do you have any case law regarding that, or?
On this, there's all kinds of case law on educational uses and religious and agriculture, but this is, there aren't any cases that I have seen that treat this particular provision of 48.3.
Thank you.
If I had, I'd probably have given it to you.
So it seems to me that, I think probably most of us are sympathetic to the project. The concern is doing harm to the strength of the bylaws. If we overrule the decision of the building commissioner, what we're saying is that there's, as you pointed out, any number of uses in 43, right? 43A.
48.3.
48.
That are, where the wording is that no zoning ordinance can prohibit those or can regulate them unreasonably. And so I'm concerned about setting a precedent. And I guess to me the issue turns on how you interpret the words zoning ordinance. Does it refer to the whole body of the zoning bylaw for any particular town? Or does it refer to each individual, subsection and so forth for each district?
I read that as no zoning ordinance or bylaw from cover to cover. You can't prohibit this use.
Well, so here's what I'm getting at. If it refers to, if this is the zoning ordinance, we allow this within this book. We just don't allow it everywhere.
That's right. That's the point.
And so For example, I think some of the other things that they refer to in that section 43 is viticulture and various farming practices. Yet we have agricultural districts, and we have industrial zone districts, and we have residential districts, and we want farming to go in ag.
Well, it's not, I mean, those things can't, you can set something up if you like, and maybe that's where people will go, but you can't have a bylaw that doesn't allow that. You can't set it up so that, at least with respect to this particular use, and the one on viticulture is a lot more complicated. That goes on for a page and a half. This one is fairly straightforward, but the bylaw cannot prohibit it, and I don't think you can say that because we allow it in one district, and that this is the position that the building commissioner has taken, and I understand what he's saying and why, but I think the statute does not say you can prohibit here but not there. It just, the bylaw can't prohibit it, and I think that's a blanket statement that you can't keep someone from operating this particular use on a particular location because the bylaw says you can do it somewhere else.
Okay, I guess I understand your point. I'm not totally sure yet I agree with it, but.
I mean, it is, right now it's prohibited everywhere but LIC.
I mean, I guess the other, in some sense, all our bylaws have been approved at the state level by the Attorney General's office, so there are prohibitions in here for various uses. I don't know how to reconcile that.
Yeah, well, it's not, because this particular use is not express. It doesn't say anywhere you may not operate a solar array farm anywhere in the town of Falmouth other than in an LIC district. You know, it's like a default position. Since it's not expressly allowed under your bylaw, it is in fact prohibited everywhere but LIC.
But then we do have that section of the bylaws that says if it's not expressly allowed, it is prohibited.
That's right. That's
And that was also approved.
yeah. But I don't know if I don't think the Attorney General has specifically addressed, you know, the question on this. Is there a conflict between 48.3, this paragraph 8, and the bylaw?
Serene has a comment.
When you read Chapter 48, Section 3, Mass General Laws, and you go through what you're talking about, first paragraph, no zoning ordinance or bylaw shall regulate or restrict. As you go down and read the different paragraphs, each one dedicated to something else, horticulture, viticulture, residential use, it's always shall regulate or restrict. But when you get to the next to the last paragraph that you read earlier, it says no zoning ordinance or bylaw shall prohibit or unreasonably regulate. So that's the only place where prohibit and unreasonably regulate show up in Section 3, and it has to do with the solar. So the town has taken it upon itself to pass a bylaw to allow the solar array in light industrial, and you can have solar arrays in a residential area mounted on the house, or I've seen some on the ground. So why do you think Mass General Law was drafted just with the unreasonable regulation in this particular paragraph and none of the others?
Actually,
Because the town doesn't feel like they unreasonably regulated. They feel like they've reasonably regulated what's in the best interest of the town of Falmouth.
well, there's a difference between regulation and not prohibiting, but the language that you cited does appear in the second full paragraph of 48.3. Nor shall any such ordinance or bylaw prohibit, regulate, or restrict the use of land or structures for religious purposes or educational purposes. I mean, so they
In those specific uses.
right, and they chosen to put solar in the same category in terms of the same degree of latitude or the same degree of control that the legislature is exercising is being applied to solar as well as to the section that talks about educational.
Well, it doesn't show the solar in that educational section, or in the residential section, or in the agricultural section. I guess that's my concern, is they gave a little bit of latitude in this paragraph by saying unreasonably regulate. The town doesn't unreasonably regulate it. They found that this, excuse me, type of solar array for this type of use, which is not residential, is regulated in light industrial. Plus, the town has allowed it in residential on the houses and in the yard. So what's unreasonable about the way the town has taken its position on allowing the solar arrays?
Well, again, back to this term, reasonable, unreasonably regulate is what the town cannot do. But to me, regulation is the second step. They're not the same. To prohibit something and regulate something are not the same. So that if once something is allowed, or if something's being used, the town may step in and prescribe some, quote, regulations for that use, which the statute does, again, with educational and religious, where they say such land or structures may be subject to reasonable regulations. So the first thing you establish is the use is allowed.
Mm-hmm.
And then, if the legislature so states, the town can regulate that use. But
Right.
that's different from saying you can have it here, but not anyplace else. That's a prohibition everywhere else.
I understand what you're saying.
And it also seems to suggest that in order to regulate it, there has to be, the town has to affirmatively act and find that such regulation is necessary to protect the public health, safety, and welfare.
Okay, do you have the intent for the bylaw that passed allowing it in light industrial?
I'm sorry, do I have the?
Yeah, the intent of town meeting when it was brought to town meeting for this zoning.
The one whereby it's now allowed.
Mhm.
I'm assuming they just decided this is a good place to have solar arrays.
Maybe that's something we should get, is the intent of what the planning board was and the intent at town meeting, the explanation. Maybe that would help.
But it doesn't
Clear up the
really,
reasonable and unreasonable.
matter if the legislative act controls. I mean, even if, I'm sure the town was in good faith when they put it in LIC, and I'm sure they were in good faith when they turned down our attempt to amend the bylaw, and I'm sure the planning board was in good faith when they decided to recommend indefinite postponement of their own article. I think everybody's in good faith. It's just what we're saying is the legislature has sort of decided that the creation of these solar energy farms is of such importance as a matter of legislation that the state is not going to allow a town to prohibit this.
And I'm saying that I think the town took it in good faith not to prohibit it and put it, maybe that's why we need the intent of that bylaw as to why it was just there and not anywhere else. But, I mean, it's all interpretation, I believe, of
Right.
reasonable, unreasonable.
Yeah, and for instance, if I don't think the town could say you can only have an educational use taking place in a light industrial district. I don't think the town could state you can only have churches in light industrial district. They've sort of given a broad protection for their own legislative purpose that these uses can take place.
Right, that's why they're exempt in
Across,
some
yes,
places.
that's right.
So I'll leave that up to the board.
Okay, so Suri, one other question is, I did ask when I was in if you could get any kind of,
I did. He didn't
opinion
have
from
time
town
to put
council.
anything in a written opinion, but he believes the town does have, that it didn't, that it does have zoning for the photovoltaic, and therefore is not, the town has not acted unreasonable, and that it's neither a prohibition or an unreasonable regulation that the town put in place.
okay, so he would sustain the building commissioner's decision.
I didn't ask him that specific question. Again, I caught him right as he was leaving, so, but his opinion was, and I don't know,
Were you referring to?
I don't know if his associate could address that or
Were
not.
you referring to Mr. Duffy? Yeah?
Not to
Yes.
put
Oh,
her
okay.
on the spot.
I missed the
Yes,
first part.
yes.
I apologize. I was,
Well, I assume that since, the building
Okay,
commissioner
well, maybe,
may have conferred with Mr. Frank Duffy before he wrote his,
right.
his letter that we're appealing, so I guess it doesn't come as a great shock.
All right, well, let's see if Pat can
Let's see
shed
if-
some light.
thank you, Pat.
Pat Harris, Associate Town Council. 48, Section 3, as Sari has pointed out, has a number of different paragraphs that each has its own little variation on the theme. And I'm not familiar with the provision about the solar arrays. I do know that Frank was asked the question, and he can provide a further explanation if you have time to wait for his opinion. But I just want to point out the references to the educational and uses. It's not applicable because that paragraph specifically says that throughout the entire town, you cannot prohibit educational use if it's by a nonprofit organization. And so that's a different variant within Section 3, and it's distinguishable from the provision that is before you today. So don't get those two mixed up.
Okay, so there's an explicit statement that everywhere in town.
The way that, and I don't have the language in front of me, and it's a little tortured because it jumps between various different variables, but the exempt educational use, which we'll be discussing in the next continued hearing. I did read that provision a while back, and I could probably find it in my file, but it provides, it doesn't say you cannot prohibit educational uses throughout the town. It says if a nonprofit has an educational use, you cannot prevent them from having that use. That was the beginning of the Section 3 Dover Amendment. And since then, it's evolved, and there's a lot of different tweaks and variations on a similar theme, but they're not the same. Each paragraph is a standalone paragraph, so don't whitewash. And I would wait for Frank's opinion if you have the time.
Okay. All right, so let's just see if there's any public comment at this time.
Looks like I'll have to talk really fast, huh? 2 minutes. Hi, everyone. My name is Dave Moriarty. I'm a butter to this project. I live on Deer Pond. Deer Pond is a major wildlife corridor. We have many, many deer running through my yard. There's the pit, there's my land, there's the pond. They come through all the time. It's a major wildlife corridor. We're very concerned about our wells. We have wells. We want to know how are you going to keep the vegetation down? How are they going to keep the vegetation down? And how are they going to keep the noise down? This neighborhood has been devastated by wind turbines, okay? We have great bylaws. We should have stuck with our bylaws. Would have saved us $20 million in eight years of litigation. That's why we have our bylaws. That's why, by not paying attention to our bylaws, it cost us $20 million, 8 years of litigation, and it divided the entire town. So this is a very, very serious situation you guys are dealing with. So I just wanted to bring that to Mr. Kirk's attention. I didn't hear him mention about our wells, about the wildlife corridor, about the noise from the inverters. The town of Edgartown, they're going crazy over there because of their solar array. It's way out of compliance. So there's so many issues here. And so I would say, you'd have to come up with a better plan, and, you know, that's why we want them in industrial areas. We don't want them surrounding residential neighborhoods. We've taken enough. We've had enough pain. So we don't need any more pain in that neighborhood. Thank you very much.
Okay. Anyone else? So, Mr. Kirk, do you have any information on noise, the possibility of arranging the solar arrays in such a way that it would allow for wildlife migration, basically to address these concerns?
Yeah, some of these concerns did come up at the planning board hearing. And I think the planning board was pretty well convinced that solar panels are pretty quiet. And I think they were going to be arranged in such a way that, I guess, if wildlife were still wanted to use that area as a place to go from here to there. I don't know if that would, we didn't do a study or anything, but I don't know if that would interfere with that or not. But certainly, once these things are installed, if they were to be installed, and given their below grade, and you know, they don't make a peep, and there's no dust, and there's no trucks or anything, it's be fenced in, and so I don't think it would be a terrible nuisance for the neighborhood. Now, maybe it will interfere with some deer getting from one place to another, but those are things, when it comes time to present a plan to the building commissioner, that, you know, can be taken into consideration.
Okay, so that leads me to a second question, which is, if we were to overturn the building commissioner here, would you be coming back for a permit from us?
We would be going to the building commissioner and having to, you know, because there are structures, so-called, and and I think most of the building inspectors or building commissioners now are, you know, are very up to date on the technicalities of what's required to mount these panels on the ground. So it would not be a special permit from the board. It would be one or more building permits that would have to issue from the building commissioner. He would have to look at sideline and setback and everything else. So I think all the other bulk regulations and so forth, density regulations that are otherwise applicable in the district would have to be complied with. And I guess if we didn't, then maybe we would have to come to the board. But I think as an initial matter, it would be just the building commissioner's review and approval or disapproval.
Well, the bylaw is absent on that. The bylaw states that it's a permitted use in light industrial C.
Right.
But if they overturn, that would be questionable because it's agricultural use and it's something that's not found. So I would ask that opinion of town council as well.
Yeah, and then, because really here, our decision is just, do we overturn or not? Not, if we were to overturn, I don't think we would be able to overturn and then impose conditions on that, right? It would be either you agree with the building commissioner or you don't.
I think that's correct.
Yeah. So I don't think there's any more, I don't want to miss anyone out there. Is there any more comment from the public? If not, I guess I would come back to the board and say,
I think you didn't address the well.
you want to
Well, you know, again, that's,
Yeah.
we're not debating right now the merits, if you will, of the plan. It's just the issue.
Well, except for health and safety is brought up by the section 40A3.
Yes,
So
yes, but
I
there
guess-
has to be, usually when a bylaw is amended, you have to show that it's, to use the phrase, substantially related to the public health, safety, and general welfare. That's a touchstone of zoning. There has to be a reason to enact something. Now, in this particular case, the legislature has said, if you're going to regulate this use, you have to show not just that it's substantially related, but you have to show it's necessary. So it will be up to the town to amend their bylaw to say we impose the following regulations that relate to this use. And if the town then wanted to say, you know, water quality or, you know, whatever category you want to pick, it would be up to the town to affirmatively adopt regulations such as that. To be honest with you, based on what little I know about solar arrays, there's no discharge into the water or into the ground. They basically sit on an open plane on these structures. So it, you know, there's no discharge or that I'm aware of that would interfere with well water or anything else below the surface.
Well, if the board's going to continue it, it is a
Well, that's-
question we could ask Board
Yeah,
of
so that's
Health.
where I really want to go.
Because it has to
is-
show the wells in the general vicinity.
So I think there's a legal point here that, you know, if that has a broader impact than just this project, which it would be good to get better defined. That's my opinion, but see what the board would like.
I mean, I have a ton of experience with this. I deal with this stuff all the time. The building commissioner was 100% correct. We are reasonably regulating solar in Falmouth by allowing it in certain areas. Agriculture is regulated. If it's not expressly allowed in a zoning district, I think you need now 2 acres. It used to be 5. But you don't have a right to have horses any way you want. So, you know, we don't need Frank Duffy's opinion. The building commissioner is 100% right. If the board wants it, no problem. But I am absolutely convinced he did the right thing and that the statute, the 48 Section 3, as Rod reads it, he's reading it correctly, and he's interpreting our bylaw correctly. And the town of Dartmouth doesn't allow large-scale ground-mounted solar arrays in all zones. We limit it to the limited industrial zone and some other zoning districts, but it's not allowed everywhere. But solar is allowed everywhere, you know, residentially. No, I mean, Rod made the right choice here. I mean, he made the right call. And if it goes to a vote tonight, I would certainly vote to uphold his decision, just on my general knowledge of this stuff. If this were improper, the Attorney General would have flagged it right away.
I'm not necessarily disagreeing. I
Yeah.
just want to make sure everyone else feels comfortable, or would they like more information?
Well, I'd like to know what the intent was on the zone change, on the light industrial allowing it. I think that's.
Light Industrial C was created most recently to allow certain things like this, the contractor's yard wholesale, because of the growing of Falmouth. And in that, they allowed ground-mounted solar photovoltaic arrays by right. So this is what was created. And again, the Attorney General did read this and did approve it.
I mean, when I read this, it seems like it opens you up to regulate.
Again, you're taking that paragraph along with everything else, and everything else doesn't say unreasonable.
No, just this paragraph.
This does, just this one, and the town feels like it's done its reasonable due diligence in providing an area where solar arrays can be located.
Absolutely.
But it's up to the board. I don't mean to,
No,
I think, that, you know, it's an ideal location. You kind of wonder, was that property really thought about? You know, I can never picture it being an apple farm or something.
no, I think there's two
you can't
separate
look at
issues.
that.
One
Yeah, I know that's
is the
nothing.
zoning issue, the other is the merits of the project going there. I think we'd all endorse the project if it was properly zoned
Right,
for
sure.
that purpose. Or if the zoning bylaw were changed to include AG as a solar mounted, as a location where you could do this by special permit. But there's a bigger issue of, does the state law really supersede what we've got written? And, if you
No.
believe Paul, no.
Yeah, I mean,
Or-
it's so clear to me, it's not even funny.
Or the better question is, did the town create it according to
comply.
the
To
comply.
legislation?
Absolutely.
That's the better question.
That's my opinion. But,
So
I
if,
mean,
and so all I want to know from everyone is, are you satisfied that you have enough information without a referral from Frank, from town council, to vote it tonight? Or would you like to wait?
I think it would be appropriate to get town council's opinion regarding 40A, Section 3, and maybe if we were in favor of overturning the decision, just to see how that would play out. And I also think it would be helpful to get the intent of the bylaw from town meeting, because quick glance at light industrial C, it is fairly restrictive, so there has to be some reason why ground-mounted solar arrays are allowed in that district.
One of the few uses allowed,
Right.
right?
And I guess the question I have is, what was voted on at the town meeting? I wasn't there. But was it to add
The
to,
most recent town meeting?
yeah,
I think it was to change the zoning of that parcel.
Just
The
that
first
parcel?
one was to change
LIC.
the zoning of that parcel. The second one
Just to allow
was
use.
to allow the photovoltaic solar arrays in agricultural, which I shouldn't have said it was shut down. It wasn't. It was indefinitely postponed, and it was a blanket vote, if I remember correctly. Passed under the blanket vote? I'm not
Yeah,
sure.
that was, the planning board asked that it be.
Right.
And my recollection of the debate on the LIC conversion was that people, at least for the most part, were saying they didn't object to the solar use, they were concerned about what other uses might be opened up if you did that. But,
I'd like to get Frank,
Okay.
town council's input.
all right, so why don't we continue this to I think we're very close. I think it's not going to be a long discussion when we come back.
We're going to have to go another day. I just can't keep doing this. I hate to do this, but, June 21st. And, is that Kimberly? Can you read my writing? Ken, are you out? Ken, are you out on May 20, or June 21st? I think that says you and not Kim.
That
Unless
I'm
you guys
aware
wanna-
of.
We've been
That's
setting
so
up
far
things.
from now, who knows?
That's executive. Can't do it there. We've got 240Bs there, 2 other variants. You don't know? Because I'm sure he won't want to go forward
Right,
with just
right, no.
4.
Yeah. No, I mean,
Is that
I
correct?
have no reason.
That is correct.
Thank
I
you.
have
Yes.
no, I have no
All due
reason,
respect to them.
I have no reason to believe I won't be here on June 21st.
June 21st, you think you're going to be
I
here?
think I'll be.
Do you want to go with that thought?
Is that
Ed?
What was the date?
June 21st, is that available for
Isn't
you?
that the, like,
That's
summer
first day of summer,
solstice
sure.
or something?
Yeah.
What?
That's like
Summer
summer
solstice.
solstice?
Yeah,
Oh, my God.
Okay. So what we need is a motion to continue this to June 21st here in Town Hall at 6:30.
6:30?
Yeah.
Not 6?
No.
Damn.
Do I hear such a motion?
Motion to continue to June 21st at 6:30.
second it.
Okay, so Robert and Ed moved. All in favor?
Aye.
Opposed?
Okay, one opposed.
Thank you very much.
Yep.
Thank you, Ed.
Okay. Okay, the next item is a continuation of 086-17, the Climate Foundation, 3 Little Harbor Road, which is a remand from, I guess from the courts, yes?
That hearing has been opened with testimony, so you'll have to introduce the new board that will member.
Oh,
So all
yeah,
you
so
need
who
is
was
the
on it? So
referrals.
who was on it was Kim, myself, TJ, Ed, and Paul, so we're adding Robert.
Because Kimberly's absent. So
Right.
Ed, all you have to do is, and I don't think there's any new information as far as referrals. There's been new information submitted by the attorneys.
Right. Yes, that's all. How much do we need to?
And everything, no, you don't want to read all
Yeah,
that.
no.
And it's been forwarded to all the board members.
Yeah.
Okay.
Okay, thank you. I'll begin. For the record, my name is Brian Wall. I'm an attorney. I have an office in Sandwich, and I represent the Climate Foundation, which is actually not the applicant in this case. Climate Foundation, well, let me just back up. We were last here on December 7th, so I thought if I could take 2 or 3 minutes just to kind of go over the context of where we've been and where we are, it would set the stage for what I think we're going to do tonight. You might recall Climate Foundation is a nonprofit, tax-exempt corporation engaged in research, study, and education on issues related to climate change. And in 2013, the Climate Foundation bought the property at 3 Little Harbor Road in Woods Hole and gave it the name of Climate House to refer to. In 2013, a neighbor filed a complaint alleging zoning violations, but the zoning enforcement officer determined that there were no violations because the property was being used for educational purposes and therefore was exempt from zoning. The neighbor was aggrieved and filed an appeal to the board, and the board held hearings in February and April of 2016 and issued a decision whereby the board found that the entity was in fact a nonprofit tax-exempt educational corporation, but that the use that was being made of the property did not meet the what's called the primary and dominant test. So the appeal was affirmed. In other words, the zoning enforcement officer's decision was overturned, and my client exercised its right to appeal and took the case to the land court. After the case was filed, I had some conversations with Associate Town Counsel Pat Harris, and we talked about a couple of things. One argument that I made was that the evidence that the board heard in 2016 was actually based upon complaints by the neighbor that brought up evidence that was 2 or 3 years old, and that another year had gone by, and that the use itself is actually changing because when Climate Foundation went into the property, it was basically a startup organization, and each and every year its use had become more and more robust. And the second point was essentially a continuation of that argument, which is that this use can continue to change over time. And so we talked about the possibility of mediating the case to see if we could come to an agreed upon solution. And Attorney Harris took the matter to the board. The board agreed that it would be at least worthwhile to do that. And thereafter, it was set up for a mediation session. And last year, in June, we met at the Gus Canty Center for almost 6 hours to hash out as much of the details as we could. And one of the things that was a focus of the conversation during the mediation was some proposed conditions that my client and I had brought to the meeting, essentially trying to make the case that if this were conditioned like a special permit or a variance, that maybe the board would have a certain level of comfort deciding that in fact it was primarily and dominantly educational. And the 2 representatives of the board that were there and are here tonight felt at least persuaded enough to recommend to the board to allow us to come back for a remand hearing. And in fact, we then went to the land court. We filed a joint motion to remand the matter. It was remanded. We submitted some additional information that was requested by the town, including floor plans, a site plan. I wrote another narrative, and we had a hearing back in December, at which we were here for probably another hour. And back then, I made the case that the use had continued to become more and more robust. The fellowship program had grown. There were actually formal classes being given each and every day during the summer, and that the other guests that were staying at the property were all scholars and had to participate in a mentorship program. And we felt, and I don't want to put words in the board's mouth, but there seemed to be a consensus that maybe we were making the case that this was in fact primarily a dominant. And then at the end of the hearing, the discussion turned to the conditions, and I had submitted those as part of my application to the board, but in the volume of materials, they somehow got put into some other papers or something like that. And so when I started to talk about them, the board didn't seem to have them in front of you. And so there was obviously a need for a continuance so the board could have a chance to review those in more detail. And Attorney Harris also suggested that she wanted the opportunity to work with the board to maybe have some input on those conditions. And also, Mr. Van Kuren brought up the issue that what about public safety regarding the fire suppression system, building code issues, et cetera. And so there was a continuance requested by the applicant, strike that, not the applicant, the one that's being enforced against. And we asked for a continuance. And in the time since we've been here last, the town's officials, the fire department and the building department, have inspected the property. And they did issue a report, and there were 3 issues that the report found. There were 2 issues with regard to some egress, some secondary means of egress. A fire ladder and one of the other matters did not meet the building code. And the fire department has not said that the fire suppression system is sufficient or insufficient. What they did say was that if it has been used consistently as a dormitory for educational use, that the case can be made that the system is grandfathered and it can remain in place. But if that case can't be made, then a dormitory requires a sprinkler system. So that I think gets us to where we are tonight. In the last few weeks, that report came into me, and also Attorney Harris sent to me some proposed, or the town's view, I suppose. What do you say, Pat? It's your suggested changes?
Right.
Okay. Some suggested changes to the conditions that I made. And I worked with my client, and we took the conditions that we submitted back in December, and some of the changes that the town sent to me were agreeable to my client, and they've been incorporated into the conditions. Some were not. And so what you have before you are 2 sets of conditions tonight, a revised set from me that, again, shows the set that was submitted in December, modified to incorporate some changes, but a larger set of conditions that is proposed by the town. And then with regard to the building code issues, obviously, we only found out about them, I think we got the report 2 weeks or so ago. It took a long time for that to be done. They're not corrected, but one of the conditions that the town suggested was that they need to be corrected, and that my client needs to have what's called a certificate of occupancy or certificate of compliance from the town in order to continue. So I think that although there's some building code issues, that condition, which has been incorporated into our set, will take care of those 2 problems. They'll have to be remedied before the use can continue on. So that's where we are. I thought that tonight would basically be a discussion about the conditions that we agree and don't agree on.
Okay, so just to be sure that we're all on the same page, on April 26th, you sent us a letter and appended the conditions. Is that the version that we're talking about?
Yeah, so that's
dated April 26th.
That's the version that I submitted on December 7th and then modified and revised after I received town council's suggested changes. So that's an updated, revised version.
Okay.
But you should have another one from Pat Harris.
Okay. I wonder whether we ought to hear from Pat before we start asking questions.
Just a couple of comments. Pat Harris, Associate Town Council. There is one piece that the board will have to substantively address, and it dovetails with the special conditions, but it is prior to writing up or deciding on the special conditions, there has to be a consensus that this is an exempt educational use. So that has to be thought about. The fact that I submitted these proposed special conditions doesn't mean that the board has yet made the determination that this is an exempt use. But the intent of these special conditions is to, this case has been going on for a couple of years, as Attorney Wall outlined for you. Your initial decision was that this was a lodging house use. You didn't find an educational use. And Attorney Wall did a good job presenting his client's position that it's evolving and that the board might be able to now, with more information, find that it's an educational use. But my recommendation is that if that finding is made, if there is a determination that it is an educational use, that special conditions be included with that determination, which would allow this kind of amorphous use to be defined more specifically. And counsel and I have been working hard to come up with materials and information that might help you with that. And you will notice in the special conditions that were forwarded to the board by my office, you know, there's definitions basically of what is the fellowship program. What is it? Does it comprise of education and research and workshops? Define it. What is a mentor? Define it. How many hours have to be attributable to the activities of the fellows and of the mentors? How many people can sleep overnight in the structure, and what are the preconditions to their being qualified to sleep overnight to keep this as an educational use? I would urge the board to consider that the materials that came back in response to the April 26th proposal that I submitted are weakening some of those matters, making it a little bit looser in terms of who can stay overnight. And just keep in mind the history of this property, that you found it was being used as a lodging house initially. And if you're going to allow it as an exempt use, you need to be able to confine it somehow to be legitimately an educational use. I did submit and forward to you, I don't know if everybody has seen this, a memo. It was on an email form from the engineering department. The town engineer pointed out to the board that the driveway being used by the landowner is on town property. Just something, information. These special conditions didn't explicitly talk about parking, and I would urge you to think about that. I know there was some discussion about not allowing on-street parking, that it has to be off-street. If you look at the plan, that's a challenge because the driveway is on town property. The memo from the building commissioner has been described, and those determinations will be made by him, not by this board, but there is a suggestion, and I think the landowners agreed to this, that before the educational use may proceed, if in fact you vote to a determination that this is a legitimate educational use, exempt from zoning, and is allowed in the property subject to these conditions, that one of the conditions be that it does not begin until such time as they have that certificate of compliance from the building commissioner. And that gets back to the health and safety issues raised by Mr. Van Kuren, that, you know, perhaps this building needs to be sprinklered. The second means of egress from the third floor and from the second floor are not in compliance with code. There are safety issues related to that, so I would urge you to include that as a condition. Obviously, I don't want to go through every condition with you. I could, if it would be helpful to the board. I didn't have an opportunity to do this. I was trying to figure out how to do this. But when you compare what was submitted by my office and what was provided later in that day by Attorney Wall, I've highlighted where the things that he's deleted, and that might be a useful exercise on your part to see how it's weakening some of the things that I think that are important to define this and keep this as a legitimate educational use if you go down that route. Thank you.
Okay, so one other question then before. To cure some of these compliance issues.
Right,
And for example, the off-street parking.
right.
Do you have how can they do that?
I mean, that's up to the landowner and his council. They could do a number of things, perhaps find another lot that they identify for the parking, or perhaps get a license from the town to use town property. There are various ways that may
So
be
some
addressed.
kind of easement or something for
Yeah,
the purpose of
yeah,
that.
I don't think the town would give them an easement, but they might provide a license. Again, I can't speak to that because that's a policy decision. I don't even know what the parking requirements are for this use on this property, and that's another issue that the building commissioner will be looking at later. You know, but just in terms of the pieces of paper that you've seen so far with regard to special conditions doesn't address parking directly, and I think that that should be added. And I think there should be a little bit more fine tuning on the definitions, because I noticed before I came tonight that the program is referred to in various ways, and it's not consistent through each of the special conditions. On first round, my interpretation of the fellowship program, capital F, capital P, included education, research, and workshop requirements with specific time obligations. And looking at it again, I don't think that's clear. So some things need to be worked on a little bit stronger, to become a little bit stronger.
But you're saying, Pat, that the board shouldn't even look at these until they make a determination that this use is something that what the original appeal was, correct?
Yeah, and again, they dovetail. They're not completely independent, because I do not believe that they could make an independent determination that this is an educational use, in my humble opinion. But with these special conditions, defining what is the educational use, and if they don't maintain it, I mean, one of the conditions is that there's an annual review by the board, and the board would review the programs, and documentation in terms of who was staying at the facility, and what they were paid, and what grants were provided. It makes it a more substantial description of a program that you may feel is an educational use exempt from zoning. It's not easy to have two separate, and but I just want to remind everybody that you haven't yet made a determination that this is an educational use subject to certain conditions.
So I guess the question becomes, if we have to do that first,
Right.
You do.
do we have to, essentially, we've set forth what we believe the conditions appropriate
Right.
are for an educational use.
Right.
In this case, do we have to find that those have been the conditions in the past?
Well, see, this is where it gets a little confusing, because it's hard to track this down, and that's why the proposed conditions include reporting requirements. Yeah, and so it's a gray area, and I don't know if we have an agreement yet from council to agree to the special conditions that the town suggested, subject to those little tweaks that I've just mentioned, adding parking, defining the program more specifically, and being consistent.
I think the confusion is, excuse me, that you had mediation on this.
Yes.
And it's been placed in front of this board as this is an agreement. But what I want to make clear is they have to find that this is an educational use.
Right.
Not that this is an agreement.
That it has been, or
Right, right.
If the use follows these criteria, we find it an exempt use, I guess would be one way of
Right.
saying it.
I think that we might be able to do.
Yeah, but don't forget that part of it,
Right.
because this is, a long time has passed, and you haven't yet decided that it's an educational use.
Right. That's where I don't want the board to get a little lost.
I know.
No offense to the board.
Okay, and again, let's just make sure I'm on the same page. Wow, this is, yeah, that's old.
Attorney Wall's submission has a date stamp of May 1st, even though the letter is dated April 26th. Attorney Harris's is stamped April 26th. Because I've got hers, I wasn't in the office when Attorney Wall's came through.
Okay.
I was on vacation. Does that help?
Maybe. So we did put a lot, I mean, I was involved in the mediation, so there's a request for a lot of documentation that they're doing something educational. It sounds like we still have a little tweaking to do before we could definitively vote this.
I think there's a little tweaking that I would recommend, even with what I had sent on the 26th, but I also, I feel you're being put in a difficult situation where you have something that I submitted, and then later in the day you got something that was submitted by Attorney Wall.
Right.
And you, I mean, this is what I had to do to it. I was, you know, highlighting, color coding what was added, what was taken out, and what the implications were. It's a bit of a challenge, and I can go through it with you, but we'll be here all day,
Right.
all night, I guess.
But again, the vote, the discussion on what the board feels, is this an educational use? All this aside, is that not correct?
Not really right. They're dovetailed, and I guess, I think the
that's
best
what's
way of looking
confusing.
at it is that you need to come up with a set of conditions that you all agree on.
I think
And
that's,
then the vote that this is an educational use subject to these conditions.
Okay,
this,
wow.
everyone agree and understand?
The letter
Oh,
that
definitely.
Well, my issue is, when I sent these to the board, it wasn't that, okay, there's a difference here in this one, you know, versus that one. So I don't think it was clear to the board when I sent them to you, which is my mistake, but not knowing where we were
But it
going in
sounds
this
to me-
hearing.
It sounds to me like Pat still has a few modifications she'd like to.
Yeah.
A couple of minor
Incorporate.
modifications. And I can do a synopsis under each special condition and what was changed and what the impact is. I started that process, and it's very confusing for you, you know, not having lived
Yeah,
with
I
this.
think we want to have one copy to consider. That's
One document.
One document.
Yes,
That
please.
is agreed upon.
So can I just?
Well, it may not get agreed upon.
So we've come a long way here, and I think that you've seen my approach as not to be argumentative with the board, but to try to work with the board to achieve the result. But let me just say a couple of quick things about the conditions, because I don't want the wrong impression to be made. I agree that there does need to be a finding of educational use. I didn't mean to kind of smoke and mirror that. I think I just didn't get into all the details because we've been through, I think, if you remember, there was the enforcement hearing prior to the appeal, there was the remand hearing, there was the mediation session that I had with two of the members, and we've gone over this. One of the fundamental problems to get your mind around here is that case law is very clear that to be an educational use, you need not be a brick and mortar classroom like the room we're in with a blackboard. You can be something else. And what my client is making the case for is that the educational use, when you're at the college, postgraduate, and postdoctoral level, is you have people studying on computers and in libraries and out in the field, and not necessarily sitting in chairs looking at a classroom. And so that's his case, and as you've seen him at this podium, he believes passionately that he is an educational use, but the board is looking at it from a zoning perspective, which you're supposed to do, and say, well, we're not sure, and if you're saying this, we want to make sure that it's happening. And so what we've done is we proposed these conditions at the mediation that said, look, these reflect what we're doing. And if you see these and say that if you maintain this level of educational use, we will be satisfied that you're there. And at the mediation, there was some give and take and said, we'd like to see more of this and more of that. And so I'm not trying to confuse things, but we had a set of conditions at the mediation that are not before you. after the mediation, we went back and made them more robust to reflect your comments. Those were the ones submitted on December 7th. There was some desire for further input from the town's governance regulatory perspective that says we want to see these things. And Pat and I have been working very collaboratively, and she did send them over to me. And the reason why you have two sets is because when my client got the town's changes, we went through them in excruciating detail, and he came back at it from certain perspectives saying, well, that's not going to work because that's not what we do. It's this high-level educational. So, for example, there's one of the changes is about the mentor, that there needs to be some sort of quantitative way of measuring that the mentor is interacting with the students 20 hours a week, I think it says. But, Mr. Foreman, you'll remember when Mr. Von Herzen said at the mediation, some people that stay are so high in their field, like Stephen Hawking, a minute with him is worth an hour with me.
Not anymore.
10 hours. Yeah, I know, not anymore, but that's, I don't know about the bio people. But in any event, that's the point. So there's no point, there's no effort here to not be fully forthright. And the reason why there are two sets of conditions is just because we couldn't reach agreement. And so what I envisioned was I thought that the board would review it and then make a decision. And I think that they are dovetailed, as Attorney Harris said, that I think what the purpose of the conditions is to say, we've taken your representations that you've made in writing and in our discussions, and we agree that if you are in fact doing that, we are comfortable enough finding you primarily and dominantly educational. But as President Reagan said, trust but verify. So we have these conditions that are going to say, you've got to do this, and you've got to report to us. And if you keep up that level or make it more robust, we're okay with it. That's how I saw the whole process. We can go through it here, or we can ask for further continuance.
I don't think we should do that. I just think we need to reconcile to
The one document,
to a
yeah.
single document, come back with that. And, I mean, so, well, from the point of view of the board, let's just say, you've had a chance to look at the nature of this. We're getting close. If we had something like this, would you be inclined to say, okay? You know, something like this that we sort of got to the point where we agreed on all the details.
Yeah, I think we have to, but regarding the 26th April submittal, you know, one of the questions we asked them about the education, in here it says that it's closed for 40-some-odd% of the time, locked up. 35% of the time it's used as a residence, and the remaining is education, which doesn't leave much, which makes you wonder,
That's why you need the one document.
Yeah.
Right, so is that a fatal flaw if it turns out that that's the,
I wouldn't call it much of an educational
right?
use. Right?
I mean, I think we have the single document.
Yeah.
You've all had a chance to look at. Those details are explored in a lot, you know, in depth. How much time is it being used? Are people getting paid to teach there? You know, how many students? We agree with you about the brick and mortar. It's not necessary to have, you know, a bunch of chairs lined up in front of the blackboard. But there were performance standards that we tried to make during this mediation somewhat quantifiable. So that's one set of issues, and I think we get the single, I think it's not going to be hugely changed from what you've seen. Is that sufficient, I guess, that you might find it within your hearts to approve it? And then the second big issue, I think, is the compliance issue. Because right now, I think it's very challenging for them to comply with the safety and, you know, fundamental issues.
Especially since it's evolved so much, because if you remember when we were in the appeal hearing, this was going to be for kids. During the appeal process, it was for kids, maybe 8 to 10 kids.
Right.
So that's where an issue, but now it appears that people will be staying there in off months. So regardless, if it is going to be an educational use, that really needs to be brought up to public safety standards for an educational, whether, you know, it's an actual brick and mortar school, if you know what I mean, or if it's based on the people staying there and working at MBL, Hui, there's still safety standards that change it from residential to that.
That is one of the reasons why one of the conditions is a certificate of compliance from the building commissioner, because he would treat this as a dormitory, and all the safety precautions necessary would be required before they'd get a certificate of compliance. And that's why that is listed as a condition precedent to initiating going forward with the educational use.
And fire safety.
Ed brings up a really good point, though, about this. You almost look at the year as a pie, and I think you came up with 30% of it is the educational. Is that a problem? Does Regis and Whitensville allow that? I don't know the answer to that, and I don't want to make work for council, but perhaps he could brief you on that to find out if there's any support for, you know, the educational use being at this moment in time, the remainder of the year it's empty or it's for single-family use. And your point about people staying overnight and doing research down at Hui, that's not allowed under the way these special conditions put together, because anybody in Woods Hole could then say we're exempt because we have students from Hui or MBL, and that's not.
What I was talking about was what was brought up at the initial hearing.
Oh, all right, yes.
That's what all this was about. It was going to be children and then interns who will be at Hui, and that's what I'm saying about it. It's totally evolved. But the safety standards still need to be applied, and you just explained.
Right, right.
And what about the egress that goes onto town property?
Yeah, the secondary egress on the second floor is in the layout of the town way. That is included in the building commissioner's memo to you. So those are things that he would address specifically. And one of the conditions that's included in these special conditions is a requirement under your provision in the bylaw, which allows for a determination by this board that it's an exempt educational use. But it also says that if there are dimensional or parking requirements that are not in compliance with zoning, a special permit from the planning board is required, and that's another condition included in. I mean, it's a lot of detail, and but there was a real attempt to make it so that this is really holding them to the fire, that this is, you know, there are mentors, there are fellows who really are coming from accredited programs, not just somebody who's going down to another lab to do legitimate work, but basically it's being used as a lodging house, which was your first concern.
Has there been a determination of the actual allowed occupancy in the structure that exists?
Well, one of the things that the number of beds, and
I only
I
ask
don't
because it
know.
relates to students or what the size of the program is, and if you don't have the occupancy allowed for the size of the program that's proposed,
right.
you
I'll double
catch.
check that with Rod.
It's
because
based
one of
on the
things-
size of the bedrooms.
Yeah, no, we
That's
and the
what-
number of
counted
bedrooms.
beds, and I think we
counted
came
beds
up
in
with
the rooms.
16.
Yeah, and limited it to 16.
But
yeah.
you have to check with the Board of Health, because a certain size bedroom can only sleep so many. So if you looked at the beds
Well,
that
and then
were in
you-
the
and then
initial
if you-
floor plan, that may not be correct.
Right.
If you went on the count of
But-
16 and assume 16, and you look at some of the proposed conditions and it's 16 just fellows, there is no room for the
Yeah, we noticed that.
mentors or.
So that's a tweak that we might need to
Yeah,
make.
I believe, yeah, again, because you might be looking at the wrong version.
Right,
I mean,
right.
I believe we addressed that, and that's very confusing to all of you, I recognize, the way that it came to you. What I can do is work with Attorney Wall to see if we can finalize an agreement, and where we can't, I'll have a bullet underneath explaining
Good.
where we disagree, and the board will decide what you want to do.
That's perfect,
Yeah,
right?
that sounds good.
That's good.
Okay, so again, this is going to have to come back.
Would you like me to send something off to the health department and the building commissioner
What's
on
the
this
pleasure of
number
the
of
board on
bedrooms
that?
and occupancy?
Yeah, I'd like to do the occupancy.
Yeah.
So
Okay, so are we still looking?
To
Is June
continue.
21st going to be the date for everything?
How long do you think this will take between the two attorneys? I know you're
We're not
both
going to
busy.
stop on this one because it's really fresh. I want to wrap this up, so the 21st is very doable if that's what you're
June
suggesting.
21st?
Is that what you're suggesting?
Yes.
Oh,
Yeah.
I
You have a
can
conflict?
initiate that, and I'm quite perfectly fine with that timeframe.
Yeah.
But just that night, I've got something going on. Maybe the week, the one before or after.
I don't have hearings scheduled. Summer's very tough for me to schedule. We do every other week.
Okay.
And the board has been having to do 3 and 4 in a row lately. So it would be up to the board. Would you like to set up a new hearing date? Look at the bottom of your scheduled hearing dates.
Not really.
Yeah, I agree with Paul.
Yeah, I mean, you know, not really.
No,
Well,
she
then,
was just trying to find it.
I mean, I understand, you know, I understand the issue, but, I mean,
There's
6, 7 is busy.
7, yeah, 7.
So we have on May 24. Just those two.
7's very busy.
And then we're also going to do what? What is that? Oh. We already added May 24th. We had to add June 6th, then we have a hearing on June 7th. I'm asking you tonight about May 23rd. Then
I mean, the
it's,
24th isn't that cram-packed, is it?
Right.
excuse me, you have another hearing tonight.
Oh, yeah.
You have another hearing tonight
Yeah.
that
Take up the.
I have discussed.
Oh,
that
that's
date.
going over there? I got you.
I apologize, but,
21st to 7/12.
Well, 7/12, something's gonna come up, we're gonna need to meet in
well, then you
July.
want to do June 14th? You want to throw in another June date? We got the 6th, the 7th.
I
Might as
like
well have
having the
14th and the
alternate weeks
21st.
off.
Yeah, I do too, it's just, you know.
You know, you can't go from all the way to August without,
Yeah, I
from
mean-
June
I
without.
mean, I enjoy this, but you know,
Pshaw.
I'd like to go to the club a couple nights in June,
You're talking the gym, I'm sure.
the gym.
I mean, July 12th would be the next one. Something's gonna come up where we're gonna need to meet on July 12th, don't you think, or no?
Sure. And this could be it. Is this too far out for you?
No, it doesn't.
July 12th, then,
All right.
at 5:30?
5:30, great.
Sorry. Had to
6:30.
throw it in there. One of these days.
All right. Can we have a motion?
Motion to continue to 12 July,
6:30 here in Town Hall,
6:30.
and this is climate.
I'll second that.
Okay,
And I
all in
wish-
favor?
Aye.
All the board members put that on their calendar because it won't go forward, I'm sure, with just 4.
Okay.
Right?
Great, thank you.
Thank you, I appreciate it.
Yep, sorry we couldn't get it resolved. But we're making progress.
Thank you.
Okay, so now we come to 016-18, the Captain Hamlin House Association, a continuation, and this is a shed at 606 West Falmouth Highway.
Oh, okay.
Thank you, Pat.
We're getting there. So this has been opened, so we don't need to
It's been
open it.
opened.
Is there anything new
We
in the
just
file?
continued it, so there's one letter in there, I think, 1 or 2, Ed?
2 in opposition and 1 in approval.
Yeah.
Okay, and then if we just can get the plans, then I think we're good. And,
Mr. Borselli is
Mr.
present.
Borselli is here for the applicant.
Mr. Chairman, want me to proceed?
Yep.
Good evening, Mr. Chairman, members of the board. For the record, my name is Michael Borselli from Falmouth Engineering, and I represent the applicant, Captain Hamlin House, joined by Stephanie Krebs, who is the Condominium Association President, and I'm also joined by Sarah Bedingfield, who's a unit owner and a member of the association. We've applied for permission to modify a previously issued special permit to allow an existing shed to remain in place. We did submit to the file some photos. I have some just to pass around in case you have not had a chance to see them. They're just photos of the shed on the landscape, what it looks like.
There's several.
We're here because the shed was installed on the property without first obtaining a modification from this board. What I like to do is just generally discuss where it is and how we got here, and then turn it over to Stephanie to give you the particulars, because she's intimately familiar with how it happened. So the property is at 606 West Falmouth Highway, with frontage on the West Falmouth Highway in this location. There's two buildings on the property, one in this location and one in this location, with residential condominium units within both buildings. There's a driveway, access, and parking. There was another matter related to the application relative to a dumpster that was not on site, and it was a condition of the board that there be a dumpster on site year-round. The applicant has addressed that concern and has basically reinstituted a situation where there'd be a fenced-in enclosed dumpster on site year-round. The shed in question is located in this location. It's at the very back of the property. It's set back almost 27 feet from a common boundary to the west, and it's set 33 feet from the common boundary to the south. The shed measures 8 by 12. It's 96 square feet. The condominium association had come to the conclusion that they could use a shed for what people typically use sheds for. They thought it was reasonable. They innocently did not realize that they needed to come request a modification of the special permit. The shed actually is of a size that it doesn't require a building permit. In fact, Ms. Krebs was actually led to believe that there was no permit necessary. So they acted innocently and without any premeditation to do something without necessary permits. So we're here tonight hoping that you can modify the special permit to allow the 8 by 12 shed to remain. And with that, I'd like to turn it over to Stephanie just so she can explain the situation from her point of view.
Good evening, I'm Stephanie Krebs. Nice to meet you. I'm the current president of the association that's located at 606 West Falmouth Highway. So basically, I wanted to point out that we've been discussing the shed for a couple years, and we recognize that there's a need for the shed. Maybe I should look at the diagram because...
Stephanie, you have to take the microphone with you so the TV people can hear you.
Thank you.
Thank you.
So if I look at this diagram, this is West Falmouth Highway, and this is what we call the main house. This is what we call the barn. Those are just our nicknames. There are 9 units between the two buildings. There are 4 in the front building, the main house, 5 in the barn. And what we've had happen is that there is a, if you look over here, there's a, actually I think it's right here, there's an entrance to a basement, so you can access that from the exterior. In this building, there's a basement you can only access through a particular unit. So what's been happening is that residents have been using the common basement in the first building and running into a lot of difficulty with shared space. And so that's been a problem that's been kind of growing for a few years. In addition to that, we've noticed that if you look at the different decks around the property, that people have been storing bikes and kayaks and other things that shouldn't really be stored there. So we became worried a little bit about the modes of egress given the fire safety constraint, and also just the fact that a lot of residents are over 55. So we didn't want to create any kind of health hazards by leaving this situation unaddressed. So that was really the motivation to insert a shed. And as Mike mentioned, it's really for bikes, kayaks, anything kind of for exterior use. So the way we went about the process was by doing some research. So I don't remember which department I called, but I called someone at Town Hall and kind of asked what the requirement would be for a shed. And they sort of told me it had to be under 200 square feet, I believe, and at least 3 feet from the property line. And it had to be at the back or side of the property. And this is from my memory, so I'm kind of remembering from maybe a year ago.
Pretty accurate.
So, so we made sure to design the shed so that it was 8 by 12, so it would fall under the 200 square foot limit. And I talked extensively with the neighbors on this side because my main concern was that there's essentially a giant yard here, so we didn't know exactly where the property line was, and I wanted to make sure we weren't close to impeding their side of the property line. On this side, we were told the property line was here, so we knew where that was. We made sure we were definitely within bounds. So those were the requirements we were aware of. And then as it was being installed, we were informed by, I think, a third party that we were in violation of something. And so we kind of became alarmed, so I called the town again. I'm not sure, again, who I spoke with. But the guidance I received was to go back to the website, check the requirements. I double-checked those. They were the same. So we felt we were in the clear. And then we received the notice that we were in violation of a special zoning permit. So that's when we became aware of the zoning permit. And I think the reason we weren't aware is because the original owner of this property was very familiar with how the property was set up as a condo association. But he unfortunately was very ill at the time, and he ended up actually passing away last summer. So our record keeping historically hasn't been as strong as it should be. Now with the current trustee administration, we're doing our best to make sure we have all these records, and we'll include the zoning paperwork. But I think that was the reason why we weren't informed by someone within the property that we had this zoning requirement. So, so we wanted to offer our apologies for violating that, but had we known that, we certainly wouldn't have put a shed in place and then come asking for permission after the fact. And would you like to talk about the dumpster as well, or?
I just want to know if it's in the same location. I heard it's back, but I heard it wasn't in the location that we approved it in.
Yes, so it's in, as of yesterday, it's now in the proper location. So what happened is our disposal company had a new driver. So when I called them and said, could you please put it back? They put it in they actually put it where it's most convenient for them. So if you look at this driveway, it kind of curves around and goes into this parking lot, and there's some big trees here. This is where the dumpster has been and is supposed to be. One of the issues we've been wrestling with is we had a very kind of flimsy dumpster enclosure that had been hammered by the disposal truck many times over the years, and so that fell apart over the last winter. And we knew it was probably going to, so we've been designing a plan for a reinforced enclosure, but it hasn't come to a point where we fund it yet, so we'll be able to fund it this summer. But with the absence of that enclosure, the driver just put it kind of, I think, over here somewhere because it's easier for him. So now he knows that it goes here, and so it's back.
Okay.
Okay. Seems straightforward and innocent error, so.
And for your, it's less than 100 square feet.
It's
So-
less than 200. It's 8 by 12.
Well, the building department was explaining that anything over 200 feet requires a building permit. Anything under 200 feet does not.
Mm-hmm.
Any shed that is less than 100 square feet has to be 3 feet from a side or rear and not allowed in the front without a special permit. If it's over 100 square feet,
Mm-hmm.
it has to be 10 feet from the side and rear.
Okay.
So this, if it's an 8 by 12, it's 96 square feet, so a
Mhm.
3-foot setback.
Yeah, so it's actually more than 10 feet.
Right, because of the tree
Shows
line.
26 and
Right.
33.
That's just for your,
Okay, we don't
Yeah.
plan to insert anything else. So.
just call the zoning board,
Now-
because you have a special permit.
Yes, we're very
Okay, let's
aware.
not overanalyze this. I'll just ask if the board has any follow-up questions.
Just one question. Stephanie, who informed you that you were in violation of the special permit?
I wasn't on site. I believe it was September 27th that it was installed, and I believe it was our neighbor who told another resident, the resident who lives upstairs of this building.
But
So,
who authored the letter?
who authored the?
Yeah, you must have been informed by a registered letter.
They were informed by me,
Oh, okay.
because I got a complaint.
Gotcha. All right, yeah, that's all I have.
No problem.
TJ?
I think it's evident from the plan, but I just want to confirm that the new shed is located outside of the 20-foot right-of-way that's listed here.
Yes.
Right.
There's actually a row of trees that extends along this, I think it's this dotted line essentially. So it's 3 feet away from those trees, so.
The plan shows the setback, I believe.
Sure. And just on my site visit, I observed the row of trees, and you would say it's buffering the shed from your neighbors?
Yes, our goal was to make it ideally as hidden as possible, so you can't see it from the road, unless I guess you're at a certain angle maybe, but if you look at our property, you can't see it. And behind, it should be completely buffered by the trees. And we tried to make it not so tall that it would be annoying to look at.
Correct.
But we were thinking about putting it over here, and we realized these neighbors would have to stare at it, and so with the trees, it actually seemed like a better location.
Thank you.
Yeah. Okay. I don't have any questions. I think it's pretty simple. Let's see if the public wants to comment. Okay, come on up.
Good evening, Paul Sellers. I live at 16 Old Dock Road. I'm direct abutter to the Hamlin House property. I actually filed the complaint to the Zoning Board of Appeals in regard to the special permit that was issued. Basically, it is two issues, the dumpster. We were glad to see that it had returned. Unfortunately, the screening that's supposed to be going around the dumpster isn't in place, as they've mentioned. That is part of the special permit. So we are asking that that be expedited, so we don't have to deal with the dumpster in the view of that. The remaining trash barrels, loose garbage barrels, are still on site, lining the property. So we'd certainly like to hopefully see those are finally removed, so we don't have to deal with those on the property. The issue with the shed, it is actually impacting the screening that was one of the conditions of the special permit. The screening was a big item back in 2005 when we were working with the developer and Mr. Hendel, the primary owner of the property. There are two plants, Leland Cypress and Emerald Green Arborvitae, both require full sun for their development. The shed is going to impede that, and there'll be a degradation of the screening over time. So that is a concern for myself and my property. Just, I guess, really emphasizing that we spent numerous meetings with the developer before this board to come to these conclusions. The square footage of the property, it exceeds the square footage what was allowed because it was a pre-existing condition. Adding the shed, again, adds to that square footage on the property. During the hearing process, the testimonies and reviewing the plans, it was brought up that there was no storage, no facilities for any sort of garages. The developer deliberately did not want to put in that type of storage. They chose instead to increase livable space to achieve the 9 units that they have now. So there was a conscious decision not to have those sorts of accommodations. And we were, again, assured that we weren't going to see this type of sprawl take place on the property. So it also brings up, this is one shed, how many sheds could be allowed? Could each individual property unit owner ask for a shed? This isn't just something that's going to impact the Hamlin House. If you've been in West Falmouth, there are numerous condominium developments in the village. All of those are under special permits as well. So we just don't want to see a cascading effect throughout the area where you could now have precedent set to exceed the square footage of the lot and keep adding more and more sheds. So we would ask that you please enforce the zoning special permit that was put on this property to protect us. We've had these protections for some 13 years. We'd like to see the screen, the integrity of it be maintained. This is essentially the third complaint I've had to file over the years regarding this property. So we would just like to be able to make sure we establish that those conditions are met and upheld.
Okay, thank you.
Thank you.
Anyone else? Yep.
Maureen Harlow Hawks, 9 Old Dock Road. I am not a direct abutter, but I live right here, and I look down the lane. And could I just look at this plan? Because I
Sure.
did, when I came in to look at the file, this plan wasn't in the file at that time, so
It's the same plan, this
Is it?
one's just colored.
Okay. So, this is the right-of-way, and it's the
That's on
new-
Captain Hanlon's
the- yeah,
property.
the new shed shows a 26.6 to the property line of Mr. Sellers. In the special conditions of the special permit, there was no structures to be allowed within 10 feet of that easement. So I just think you should look at the special conditions. And I actually wanted, now that I saw that, but the new owners are at a disadvantage. When these condos, as Paul said, West Falmouth everywhere is getting inundated with condos and the density of condos. And what happens is you get creep. They all want the amount of buildings and the money. So they get overbuilt. The practical aspects of it, we watch it all the time. The men don't have garages or sheds. And it's a really bad thing. In this particular project, there used to be a shed in the back. And that was what we all recommended that they use, because this was going to become a perennial problem at some point, and now here it is. I don't know how this board, or in all these projects of special permits, that there's a trail somehow for these owners when they buy these condos. We had meeting after meeting after meeting with the original people. Now these new people come along and it's all gone. All that, history is gone, or requirements. Is it in their deed when they purchase these? How do they know what their requirements are?
It should be in their master deed
Okay.
and their association.
Okay, so there is a paper
Documents.
trail for them. Excellent. Then the other big issue that I have is that there were supposed to be no seasonal rentals here. And again, everything starts to just slide and creep. And these have been seasonally rented. There were no structures within 10 feet of the lane. The dumpster was supposed to be shared with the Ideal Spot and the condominiums, but the Ideal Spot is now condominiums. And all access was to be in and out of 28A. No use of that lane by any of the owners except for Mr. Hundle, who was the primary owner at the time. And they use it all the time, which is not a big deal, but if they understand that there are conditions to these projects for their density, that's why they're called special conditions. And we always end up being the bad guy. They're our neighbors. We don't want to be bad guys. They're part of our village. But if we keep you let the creep happen. I mean, I go up and down and I see it on all the condos, the sheds and the mailboxes and the whatever, that are all just slowly, the extra parking space, and now the impervious surface has increased. But, it's not really much, because each one of them only does one little space. That's the problem with all of these projects. And I'm not adversely against the shed, but I just think it sets a precedent of what we did not want to see there.
Okay.
And then the neighbors on the south, the Oldenburgs, they saw orange, which I'm now glad that there is a plan, because they saw orange tape on the shade trees that were part of the old permit as well. And they saw these ribbons on their property, and they didn't know what they were for. So they went out and had a surveyor survey the line, and they were their trees, but the condos were planning to cut them down or in decline. So again, not knowing where the boundaries are is a big problem.
Let's confine it to the discussion of the shed, because that's,
Well, then I guess
that's
what I
really
would
all
say
that's
is,
before us.
okay, so, well, we've been sitting here a lot tonight,
So the special permit does not limit them to, it just says no commercial retail or commercial accommodations, which is uses a hotel, motel. So they need to look to their master deed or restrictive covenants through their association as to the rentals. This board did not condition that.
Okay. All right. Well, then I guess, not to be the bad guy, but if we allow the shed, then we're just, after the hundreds of meetings that we had with Billy Bent and Bill Hundle, that we would not see this happen, and here it's happening. I would just say that I don't want to see the precedent set that we now have a shed. And the dumpster, again, it needs to surround and not to,
Yeah.
whatever. Yes, I'll keep it.
Point's been made.
Point's been made.
Can I answer some questions?
Sure.
Forgot which ones were, what order, but I guess the main question is, will there be more sheds? And I would say, with as much certainty as I can promise, that we have no plans.
To the board, honey.
Oh.
No, I mean, direct your
sorry, to this
remarks to the board.
Yes, we have no plans to insert any other structures on the property. It's really just this one shed we feel will suffice for all of the units, and that was one of the goals we had, was to make sure that we were thinking not only of today's owners and what they might need in terms of storage, but in the future, if somebody moves in and says, I have a bike or I have a kayak, that this can accommodate that, and expressly to prevent having more buildings. And we don't want to see the property sprawl either. We're very concerned with how it looks, and people come there because it's serene and quiet, so that's a
Certainly
premier concern.
Looks nicer with the bikes and the kayaks in the shed than strewn around the
Yes,
property.
I think all over our decks and the yard is not ideal. And we've had people try to hang them on the fence here, and that was not welcomed by the neighbors on this side, so we want to avoid causing those issues.
Your lot coverage by structures now is, do you know what it is?
18.2.
You got 3 different zones there.
The overall lot coverage is 18.7%.
And what's permitted?
20, up to 20.
So you're still well below the allowable lot coverage.
In all 3 districts.
Okay. I think from the point of view of zoning, that's a key issue.
I would say
Includes
we
the shed.
actually have a very collaborative relationship with these neighbors. So we actually talked about who should mark the property line. Oh, sorry, we wanted to mark.
Let's stay on the shed,
Forget that issue, okay.
I
But that
think
came
that's
from the
all we
shed.
really need to focus on for this
Okay.
permit. Okay.
Sounds good.
The shed and the dumpster is what
Yes.
we're focused on.
Yeah, and the dumpster, that was, we were under some cost pressures because we're renovating the main house. There was, unfortunately, the
Yeah,
developer.
you made that point.
So,
You made the point.
okay.
I think we understand. That your intent is to enclose it as soon as you have
Yes.
adequate funds.
Mhm.
Okay, so I just want to be sure that everyone who wanted to say something has said something. And ask if the board feels they have enough information.
Yeah, I think we do.
Yeah.
Okay. So the next thing to do then would be to close the hearing.
Motion to close the hearing?
Second.
Okay, moved and seconded. All in favor?
Aye.
And aye. Okay, any discussion?
No, I'm fine.
Okay, someone want to
No.
make a motion?
Anyone?
I'd like to make a motion to approve the installation of the shed.
Okay. Modification of the special permit.
Yeah, I'm sorry, the modification of the
Right.
special permit
Second.
too.
Okay, and do we want to make any findings? I think as to lot coverage being still under the maximum, setback being appropriate,
Use
Need for storage.
as testified to.
right? This will result in
Cleaning up the
actually having the property look better because the materials that have been strewn around could be in there. Also, maybe we could find that the dumpster has been, although I don't think it necessarily pertains to this.
Well, just say it's replaced, it does, that was part of the violation, so.
Okay, that, yeah.
Just
that-
It's
that-
been
that-
replaced and testimony was that they're going to
They're going
enclose
to
it.
enclose it, so the special permit will be, conditions will be adhered to.
No derogation, and is that that's your only condition?
Per plan? Did we say that?
Yeah, I think, Yeah, well, we're moving from findings to per plan, sure.
Yeah.
Yeah, I don't know if I actually, Sri, do you remember about this, whether there was something about nothing within 10 feet of the right-of-way?
No, there was nothing, I checked it.
Okay,
The right-of-way is on this property, and the shed is 6 feet this side of the right-of-way. It's a setback of 26 feet, and if you look back at the old deed, it tells who can travel through that right-of-way. Not everybody is allowed to. But that's why the board made the trash come in the way that they do come in. And I believe it is in the association documents that they cannot use that right-of-way.
okay, so the residents should not use that.
Right. And they can't. I mean, if you go out there and look at the site, they can't get over,
Right,
That
no, there's a
right-of-way.
nice tree buffer, nice.
well, even further down, there's not as many trees, but they still can't get through there. So,
Okay,
and just,
conditions then, per plan, and.
no derogation.
No derogation, and that they.
And you should probably just,
They will, should we include some deadline for enclosing, by the
sure, you can do that, and then
By
they can always come back to the board to
July
extend it.
31st or something? Think you can do
Or
it by then?
August, whatever. August 1st is a good date usually.
Okay,
And you might want to condition, because they were unaware, even though it goes without saying, when you have a special permit, when you add a structure, it's required modification, but you just might want to condition no other structures, accessory or
yeah, I
otherwise,
think that's,
without prior approval from the board.
yep.
Yeah.
Okay?
Sounds good.
Okay, and hopefully everyone's heard everyone's concerns.
Do you want to add anything about, to make sure they maintain that buffer? So, because Mr. Sellers was worried about the plants not getting enough sun. So do you want to make sure that? you
Sure, the only thing I
maintain
noticed was, it looked like one of them had been,
From the storm, probably?
from the storm, had been damaged a little, but,
So to maintain the buffer as,
okay, so, yeah, so maintain the buffer adequate to prevent
thank you.
visual impact from the shed. How about saying it that way?
Yeah, sounds good.
Okay,
Go for it.
is everyone happy with the motion?
Yes.
Okay, all in favor?
Aye.
So it passes.
Take a 5-minute break, Mr. Chairman.
5-minute break, okay. 5-minute break.